Welcome to the Resident One video series. We will be starting our coverage of tax topics by discussing the 5 types of filing statuses which are available to taxpayers. First, we have the single filing status. You will see listed at the top of the bar, if you're looking at here at this particular picture, you'll see married filing jointly, there is married filing separately, there is head of household, and there is also qualifying widower. Now, these different options do have an impact on the tax return for a variety of different reasons. One is the actual tax rate, and the tax rate will be determined based on your filing status. Secondly, there are certain deductions and credits that are not going to be allowed, also depending on your filing status as well. The tax rates are relevant because a particular tax rate will give the taxpayer a tax benefit, which means that they will potentially have a reduced amount of tax liability depending on which status they qualify for. This slide shows us once again the 5 different types of statuses which are available to individual taxpayers. Now, what's important to note on this particular slide is that the date that is relevant for determining what filing status can be used for a taxpayer is December 31st. So it doesn't matter what their status was at any other point in the year. It is what is their status as of the date of December 31st. A taxpayer will have to file based on the single status classification if that particular taxpayer was either not married as of December 31st, was legally separated, or divorced. And when we're using the term legally separated, this should be documented by some type of legal document provided by the court. Or the individual was widowed at the end of the year and did not remarry. If you're looking for some additional information as you're working on tax returns in terms of how these classifications work, please refer to publication 4012 and the filing status tab. But we will discuss them some more in detail as we go forward. The next filing status is married filing jointly. This particular status is very beneficial because it actually produces the lowest amount of tax liability when we are using our tax rate tables. There's one return that's actually being filed for both spouses, and just so that you know, marriage is determined based on the law of the state of which the individuals are a resident. So if you are a resident of the state of Massachusetts, in our particular case, a couple who of the same sex can actually be married, as that is the law, and it is recognized as at the federal level that they are married individuals for the purpose of filing a joint tax return. The individuals as of December 31st must have been married and lived together, or if they lived apart, they must not have been legally separated or divorced, which, as I noted before, legal separation would require a court document, or in the case of a divorce, there would be a divorce decree. They can live together, and they recognize common law marriage, and common law really follows the state as well. In the state of Texas, common law exists. So if you live in the state of Texas and you have lived together in a home as a married couple for at least 7 years, the state of Texas will recognize you as being common law married. And if you are recognized as being common law married by the state, then you are treated as if you are married for the purposes of filing a federal tax return. The last issue that we would contend with here is that they must have not remarried after a particular spouse have died. So this is in the case of a widower. If someone's spouse has died and they have not remarried by the end of the year, then for that 1 year, in the year in which this spouse died, the surviving spouse may still file as married filing jointly. Married individuals may also file married filing separately. In this particular case, each individual is going to file their own tax return, and their filing status, the box that's going to be checked off, is the married filing separately box. Taxes are generally higher. There is what most people have noted has been called historically a marriage penalty, and which is applied in this particular case because they are filing separately. And what does that mean? It just means that the tax rate table for a person married filing separately is going to be higher, so less advantageous than if they had filed married filing jointly, which we discussed on the previous slide. There's some additional penalties that apply in this particular case as well, such as people who file married filing separately are going to lose the availability of some credits and also some deductions which would have been allowed to them should they had filed married filing jointly. Why is this done? Well, the main reason it is done is because we don't want taxpayers filing married filing separately in order to reduce their income just so they could qualify for certain credits or certain deductions which they would not have qualified for had they filed jointly because their income was too high. The head of household filing status is one that's actually taken advantage of quite a bit. People claim it that really should not be claiming it. So we should be very careful when we're trying to determine who qualifies for head of household status. And again, why is this important? Is because based on your filing status, if you were head of household, you would seek the benefit of having a reduced, ultimately, tax liability because you would have more favorable tax rate. So we need to make sure that people actually qualify. And there are several rules that come into play when we're trying to determine head of household filing status. First, the taxpayer is either unmarried or if they are considered to be unmarried, which what do we mean by considered to be unmarried? If the taxpayer, as of December 31st, is considered to be unmarried, that is based on a time period. So the taxpayer in this particular case may have been married, but has not lived with their spouse for the last 6 months of the year. So let's say it's 2018. The taxpayer has not lived with their spouse for the last 6 months of 2018. And that must be something that is intentional. It is because they are separated. It isn't because potentially the other spouse is working a job at another place. And as long as they are still in a relationship, so to speak, then this particular individual will not qualify. It must be an actual separation, and it must be for at least 6 months of the last part of the year. The person who's trying to claim head of household also must pay more than 50% of the cost of upkeeping the home for the year, and they also must have a qualifying person living with them that has lived with them more than half of the year. So as you can see, there's consistency here, right? More than half of the year, except for temporary absences. What we're talking about in temporary absences is, for instance, this perfect scenario: you as a college student, you're out of your family's home because you live on campus for so many months out of the year. For tax purposes, the IRS treats that as you're still a part of the home, even though you may be away at college for 5 or 6 months at a time. A qualifying person would have to be either a child, it could be a parent, or it could be another relative. And we will talk more about qualifying children and qualifying relatives in a different video. As we see here, this is just noting what I just mentioned on the previous slide. Head of household requires that there is a separation from the spouse. It requires that there has been more than 50% of the cost of taking care of the home has been paid by the individual trying to claim head of household status. They must have lived apart for the entire last 6 months of the actual year, and they must have provided a home for a qualifying dependent child, a stepchild, or authorized foster child, and again, maybe also additional relatives, which we will discuss in a later video. A taxpayer may also qualify for head of household even if they are married to a non-resident alien if their spouse is a resident of Mexico or Canada. The qualifying widower filing status is also very beneficial. It's just as beneficial as if the person was able to file as married filing jointly, even though their spouse has passed away. Now, as I mentioned before, in the initial year of the spouse's death, the widower would actually file as married filing jointly. But in the next 2 years after the year of death, the qualifying widower may select to file as a qualifying widower, which means that they will still be able to use the married filing jointly tax rate table, which, as I mentioned, is the most beneficial tax rate table, which means it will allow for them to have the least amount of tax due. But in order to qualify for the qualifying widower status, the taxpayer must not be remarried at the end of either of those 2 years, and also the taxpayer must be providing the cost of over 50% of the cost for a home and the support of a qualifying child. And in this case, must be for the entire year, versus in the case of head of household, which said it only had to be more than half a year. A qualifying widower must provide the support over 50% for a qualifying child, and it must be for the entire year in order to be able to use this beneficial tax rate table.